બતાવી દીધી છે. હવે પછી
ऋषिताबेन घनश्यामભાઈ संजय कुमार सोना संजय कुमार गणेशजी चंदनसिंह बलदेवभाई रमेशभाई हाजर विश्वनाथ कबूराभाई
એ નથી સર, એ કઈક બીમાર છે.
બેસાડો.
निशांत उर्फे भूवो
બેસાડો. જી સેકન્ડ સેટિંગ.
बिस्मिल्लाह खान पठान हाजर मुजफ्फर खान हाजर तौसीफ अहमद कादरी
એફએસ માટે છે. તૈયાર છે. સારું. આજ પેલા ખાલી લઈ લો. હા, જે સેશન સમજાવતા હોય છે.
हाँ सर रामभाई नगजणभाई वकील जी जेबी बिहोल वकील जी एपी झाला वकील जी आडी परमार आडी परमार आया सर
આરોપી અરેદાર આવે છે.
અરજદાર આવે.
બતાવી દે છે.
क्या
સારું. વેરીફાઈ કરાવી લેજો. ચિમનભાઈ, ગીતાબેન, સારું. બેસાડો.
लाला भाई करशन भाई
તો ઓર્ડર વાળી જ છે.
जीवा भाई रामा
ઉપર પછી ઓર્ડર માટે.
जीवा भाई अमरा भाई हीरा भाई देवा भाई पीएसआई श्री एजे सोलंकी
નથી ને? એટલે આને મીણા આને બચ્યું છે હીરાબાઈ ને.
ना साहब ये बजतुं ज नथी पेला एजे सोलंकी
સારું. તો આજે બે નો રાઈટ ક્લોઝ કરીને એફએસ ઉપર મૂકી દઈએ. બીજા કોઈ છે બાકી આમાં?
હવે બધા ફરિયાદી બાકી છે
અને આયો એ કઈ મહેનત નથી કરી, તો આજે રાઈટ ક્લોઝ કરીને એફએસ ઉપર મૂકી દઉં છું. સારું. 21/11
सतपाल सिंह खेमसिंह बता जा
ચારે ચાર આજે બેસાડો.
मेला भाई भला भाई वकील सिंह हमेशा
સર ડિસ્ચાર્જ ના હિયરિંગ માટે 3 મુદત થઈ, એમના વકીલ આવતા જ નથી સાહેબ.
આપણે એનું રાઈટ ક્લોઝ કર્યું છે ને?
હા સર.
હિયરિંગ નું રાઈટ ક્લોઝ
જી સર.
આજે ઓર્ડર માટે. બેસો.
प्रकाश भाई पोपटलाल
લિસ્ટ આવી ગયું છે?
ના સર, બાકી હશે. આ લગભગ રેડી છે. આ 4
7 જાન્યુઆરી
પ્રવીણસિંહ ગેમરસિંહ. પ્રવીણસિંહ ગેમરસિંહ. વી.આર. વાણિયા. વી.આર. વાણિયા. વી.આર. વાણિયા. વકીલશ્રી કે.આર. ત્રિવેદી. વકીલશ્રી કે.આર. ત્રિવેદી. જગદીશભાઈ શિવકુમાર. બધા જ
બે કંપની અને 4
જી સર.
લિસ્ટ માટે છે.
હા સર.
લિસ્ટ માટે 8
એમએસસીપી સિવિલમાં
સાત સેકન્ડ સિટિંગ. તોસીફના વકીલ કોણ આપેલા લાગે છે ટિમ્બલિયા. બોલો. મેડિકલ પેપર્સ મોકલો પછી હું મુદત આપું. મેડિકલ પેપર્સ હોય તો જ મુદત મંજૂર થાય.
તારીખ આજની હતી પછી 25 તારીખ હતી પછી 2
મેડિકલ પેપર્સ તો જોઈએ ને. આમાં પાછું એક્સપિડાઇટ થયેલું છે ને સુપ્રીમની હમણાં જ રીટ આવી છે લગભગ આમાં જ છે. અચ્છા નહીં આ બે બિસ્મિલ્લા ખાનમાં ને મુઝફ્ફરમાં એક આવ્યું છે ને રીટ. એમાં આજ પછી 25/11 ડિસાઈડ થઈ ગઈ.
પઠાણ સાહેબ આવવાના
તો પછી એફએસ માટે એટલે જ આજની તારીખ ફિક્સ કરીને રાખી હતી પણ એમ જે 25/11 તો ફોર્મલ હશે ને એ વખતે પેલા નથી પઠાણ નથી
નથી ને ફોર્મલ નથી.
એમનું કઈક ફોરેન જવાનું સબમિશન હતું એટલે ત્યાં રાખી હતી. તમારી હાજરીમાં તારીખ તો ડિસાઈડ થઈ હોય મિસ્ટર એડવોકેટ. બપોર પછી આ બોલાવી લો ને.
બપોરે બોલાવી.
બોલો જયસ્વાલ. જયસ્વાલ ને બોલો આમાં
હા એમાં જ છે સાહેબ.
બોલો.
પાસપોર્ટ જમા કરાવી
જાતે નથી લાગતા.
પાસપોર્ટ જમા કરાવી
આજ તો કોઈ આવ્યું આજે કોઈ આવ્યું જ નથી રાહ જોઈએ. સારું. સેકન્ડ સિટિંગમાં ઓર્ડર માટે નિશાંત ઉર્ફે ગુગામાન એ વાંધો નહીં સેકન્ડ સિટિંગ. મારાથી થોડી ના પડે તમારે અમદાવાદ ન જાઓ એ તમારી મરજી હોય ને મિસ્ટર એડવોકેટ. મારે સેકન્ડ સિટિંગમાં અત્યારે ટાઈપમાં છે. બોલો જયસ્વાલ. 5/21 માં પેલું એફએસ તૈયાર છે.
અચ્છા એક આરોપી કઈક બીમાર છે એવું એમનો પેલો વકીલ છે
એટલે જ મેં બાકી રાખ્યું છે. હું આજ જજમેન્ટ આપવાની છું કારણ કે આમાં છે ને એક્સપિરિયન્સ થયેલી છે.
એમાં એ સુપ્રીમમાં પેપર પછી આવે છે.
હા એક્સપિરિયન્સ થયેલી છે ને એટલે આજ બોલો મેડમ. બોલો કયા કેસમાં તૈયાર છે આપી દો. કેટલા નંબર છે બાકી નથી માં બેઠા તારીખ આપી દો. જીપીઆઈડી માં જ લાગે છે. આપી દો તારીખ. ના ના એમાં તો એફએસ લેવાના જ બેન આપ્યા ને તમને હાજી.
અમે ડીજીપી સાહેબની પણ લેખિતમાં આપેલી છે સર, અને આઈઓ ની તપાસમાં પણ અમારા બધાના ચાર્જશીટમાં નામ અમે જ્યારે આરોપીને એના ઘર પાસે લાવ્યા ત્યારે પણ અમે એને જવાબ લખાવેલો છે. એમને કીધું કે અમારી ઓફિસ આવીને કોમ્પ્યુટરમાં લખાવવાનું, તો અમે કોમ્પ્યુટરમાં પણ લખાવી આવ્યા છીએ. જે ચાર્જશીટમાં નામ રજૂ કર્યા છે એ કોઈ જ લેણદારો છે નહીં. લેણદારો છે એના ચાર્જશીટમાં નામ આપ્યા જ નથી સર.
એટલે હવે મારી પાસે જે ચાર્જશીટ આવી હોય ને એ પ્રમાણે મારે ચલાવવાનું. તમારે તમારી ફરિયાદ પોલીસમાં કરવી પડે.
કર્યું સર,
ત્યાં કરવી પડશે.
એટલે ડીજીપી સાહેબને જાણ કરી છે કે 3 વખત અમે રૂબરૂ પણ મળ્યા એમને.
અને અહીંયા તો તમને સમન્સ અમે તમારી જ્યારે જરૂર પડશે ને ત્યારે બોલાવશું. તમારે અત્યારે આવવાની જરૂર નથી.
ચાર્જશીટમાં નામ નથી તો અમારે પછી
પણ એના માટે બેન પોલીસમાં જવું પડશે તમારે.
સોગંદનામું કરી તૈયાર રજૂ કરી શકીએ.
ના બેન એ પોલીસમાં જ કેવું પડે ને. મારી પાસે જે કાગળો આવ્યા છે ને પોલીસ ઇન્વેસ્ટિગેશન પછી મૂક્યા છે.
ચાર્જશીટમાં ફરીથી
એટલે
રજૂ
શું કરવાનું એ તમને ક્યાં તો ડીજીપી કે ક્યાં પોલીસ કે, મારાથી નહીં કહી શકાય. તો હું વોરંટ કાઢીને પકડીને બોલાવીએ. ના ના તો વોરંટ નીકળે. તમારી અનુકૂળતા મુજબની તારીખો નાખી છે. આ 2 જેલમાં છે અને એમની હાજરીમાં તારીખો ફિક્સ થઈ હતી. તો કેન્સલેશન બેલ માટેનો ફિટ કેસ છે. બેલ કેન્સલ કરી નાખીએ. પછી કેટલા દિવસ જશે? પેલા નથી તમારા કલીગ નથી પઠાણ, એમને પૂછો એ રોકાઈ જશે. ફોરેન જવાની બદલે એ રોકાઈ જશે તો તારીખ નાખી દો. પણ એવું ન થાય ને. એફએસ માં પ્રોસીજર તો આપેલી છે, એમાં તો હું કઈ ચેન્જ ન કરી શકું. રોકાઈ જતા હોય તો મને કોર્ટને શું વાંધો હોય? કોર્ટને ક્યાં વાંધો જોયું? પૂછી લો.
ક્યારે જવાના છે? કાલ.
બોલો.
એન્ટિસિપેટરી ફાઇલિંગ કરવાની છે. સાહેબ મારા ધરપકડ કરવાના ચાન્સીસ પૂરેપૂરા છે સાહેબ. પોલીસ સ્ટેશનથી ફોન આવી છે સેક્ટર 7 માંથી કે તમે આવી જાઓ કે તમારા સ્પીડમાં ફરિયાદ થયેલી છે. એટલે સાહેબ અમારે પૂરેપૂરી સંભાવના છે સાહેબ કે અમારી ધરપકડ કરશે સાહેબ. એટલે એના તબક્કે સાહેબ તમે એન્ટિસિપેટરી બેલ દાખલ કરવું છે. અને કોઈ પણ સ્ટેજે સાહેબ પોલીસે એફઆઈઆર ના કર્યો એ છતાં બી સાહેબ હું એન્ટિસિપેટરી બેલ દાખલ કરું. કારણ કે મારા ઉપર ધરપકડ કરવાના ચાન્સીસ છે.
લેખિતમાં નોટિસ મળી છે? લાવો સુપ્રીમ કોર્ટ નું જજમેન્ટ આપો. લેખિતમાં નોટિસ મળી છે? લેખિતમાં નોટિસ મળી છે?
ના, લેખિત નહીં, મને ફોનથી જાણ કરે છે સાહેબ.
એ કોર્ટ કેવી રીતે માનશે કે તમને ફોનથી જાણ કરી?
પણ મેં તો સાહેબ અંદર જે ફોનથી આવે છે
એગ્રી, આ જજમેન્ટ તો ખરું. એફઆઈઆર ની જરૂર નહીં, પણ કંઈક તો બેઝ જોશે ને દાખલ કરવા માટે.
સાહેબ મને ફોન નંબર આવે, ફોન નંબર મેં અંદર એન્ટર કરેલો છે સાહેબ, અંદર લખેલો છે સાહેબ. એ તો સાહેબ આવશે ને સાહેબ, ત્યાંથી કે છે કે મેં કરી છે કે નહીં. અંદર આ સાહેબ પરિસ્થિતિ આવી ઉભી રહી છે.
એમ પણ કંઈક તો કોર્ટ પાસે, આ માત્ર તમે
પણ મને
અરજી લઈને આવો
મને સાહેબ
એના
જાણ
આધારે
કરી
તો ન
કે આ
થાય ને.
નંબર પરથી છે આવે છે, એટલે મેં સાહેબ નંબર લખેલો છે સાહેબ.
પછી એ નંબરની કોલ ડિટેલ મૂકી દો ને. કંઈક તો મૂકવું પડશે ને તમારે.
પણ સાહેબ એ હવે રજૂ કરીશું સાહેબ જે તે વખતે આવશે
જે
પોલીસ.
તે વખતે નહીં, દાખલ થતા સમયે
બરોબર છે
કોર્ટ
સાહેબ, પણ
પાસે
સાહેબ પોલીસ આવશે એ કહે છે કે ના અમે નથી કરતો,
બધું
બસ
એના પર
સ્પીડમાં કરતી
આધારિત
સાહેબ.
નહીં. પોલીસ અરજી લઈને કોણ આવ્યું છે?
હું લઈને આવ્યો છું
તો પછી એને કઈક તો મને બેઝ આપવું
પણ
પડે.
બે જણે સાહેબ મેં મને એને ફોનથી મને જાણ કરી છે સાહેબ, એટલા માટે મેં તો રજૂ અંદર લખેલું છે
એ
નંબર છે
406 420 એટલે 7 વર્ષથી
હા, ઠીક છે.
સજા. પછી
એ-
પછી
પણ હું સાહેબ હું ના મારે તો છે લેવી જ છે સાહેબ. જો ગમે ત્યારે પોલીસ આવીને એને ઉઠાઈ જાય અને આવું થયેલું છે સાહેબ, મારા કલોલમાં હમણાં થયેલું છે રિસેન્ટલી, અને નાણાવટી સાહેબે રિજેક્ટ કરી સાહેબ. હું આવું છું ને મને કે જવાબ લખાવ બોલાવો સાહેબ, અને ત્યાં મને સીધું ફરિયાદ ભાઈ દાખલ થઈ મને બેસાડી દીધો.
એ તો જે તે વખતે જે તે પોલીસને સબસ્ટન્સ લાગ્યા હોય એ પ્રમાણે કરે.
પણ સાહેબ મને કે
કોર્ટને
તમે
તો
જવાબ આપો બોલાવો. 2 જણ 3 આરોપી છે, મને 2 પકડી 2 જણ પકડી દીધા. બોલાવી કે તમે ઉપર ફરિયાદ દાખલ થઈ. આમ કશું જ નહીં સાહેબ, મને બેસાડી દીધા સાહેબ, આવું થઈ.
નોટિસ તો આપી હશે ને.
મને કઈ નહોતી, મને સાહેબ ફોન થી જાણ કરે છે સાહેબ.
નહીં, જે તે કેસમાં તમે કહો છો ને
હા.
એમાં નોટિસ
ના
આપી
નથી
હશે.
આપી, નથી ડાયરેક્ટ સાહેબ બપોરે સાહેબ ફરિયાદ થાય એટલા માટે ઠીક છે.
પણ આમાં તમે મને આપો ને કોલ ડિટેલ્સ આપી દો એટલે હું દાખલ લઈ લઉં. બેઝ કંઈક આપી દો એટલે દાખલ લઈ લઉં. બોલ. હમ. બોલો ક્યારે જવાના છે પઠાણ? બોલો કાલે આવવાના છે? પૂછી લો. નક્કી કરો તમે. એટલે એમની ગેરહાજરીમાં એફએસ લેવાય તો વાંધો નથી ને? સારું. સોળ 11 મેડિકલ પેપર સાથે ટાઈપમાં છે હવે એટલે એ સિવાય કેમાં બેઠા છે બાકીના લાવો. બોલ.
Matter of serial number 4 and the serial board.
આર્ગ્યુમેન્ટ તમે કરવાના છો
Yes,
કે?
sir. At the proxy. Your Honor, basically, the present appeal has been filed before this honorable court, challenging the order passed by the learned trial court below exhibit. Below exhibit 5 and exhibit 43, Your Honor, wherein the plaintiff asked for mandatory injection while exhibit 43, Your Honor. The order is dated 11th of September 2017, Your Honor. Before moving, Your Honor, I would like to present before this honorable court the facts of the present case, Your Honor. The appellant herein is the original plaintiff of the suit, being special civil suit number 267 of 13, Your Lordship. The respondent number 1 herein is the GIDC, the original owner of the suit property, Your Honor. The respondent number 2 herein, Your Honor, is the legal heir of one Harishchandra Sainani, who was sole proprietor of Messer Standard Ceramics. Messer Standard Ceramics, Your Honor, took loan from respondent number 3, who is the bank herein, by mortgaging the suit property. And respondent number 4 herein is the auction purchaser,
of the said suit property, and respondent number 5 herein is the father-in-law of the plaintiff. That is the present appellant, Your Honor. Now coming to the facts of the present case, Your Honor, the suit property is situated at plot number 109 and 110 at measuring about 3,950 square meters, situated in GIDC Dehgaon, Your Honor. The said property was primarily, at first, was allotted to the firm, namely Messrs. Standard Ceramics, by the GIDC. So the original allotee, Your Honor, was Messrs. Standard Ceramics, and the sole proprietor of Messrs. Standard Ceramics was Harish Chandra, and respondent number 2 herein is the legal heir of Harish Chandra, Your Honor. The lease deed was conveyed between both the parties, that is Messrs. Standard Ceramics and the GIDC. The lease deed is of the year 1980 or 1981. With the condition, the lease deed was conveyed with the condition that the firm could not transfer or mortgage the said property without the prior permission of GIDC, which is also called the 2R permission, Your Honor. Now, the Standard Ceramics, Your Honor, took loan from the bank herein, and due to default in the repayment, default in the repayment of the loan amount, the mortgaged amount, the Standard Ceramics mortgaged the said suit property from the bank before the bank, and the Standard Ceramics failed to repay their loan and repay their dues monthly. Hence, the respondent number 3 herein, the bank herein, preferred a civil suit before the Mirzapur court, Your Honor, and thereafter the DRT came into existence and the case was transferred to DRT. It appears from the facts, it appears that respondent number 2, Shri Harish Chandra Sainani, had become a partner in Standard Ceramics, and thereafter he became the sole proprietor in the year of 1996, Your Honor. At this juncture, the very most important thing which needs consideration is that Standard Ceramics, before mortgaging the property, Your Honor, had neither take permission from GIDC for such mortgage, nor respondent number bank herein is in possession of the original lease deed, Your Honor. Those two grounds are my primary grounds, Your Honor, that there was no original lease deed before the bank, and second, that the permission of the original owner, that is GIDC, was not taken before mortgaging the suit property, Your Honor. The mortgage was conveyed on the basis of a certified copy, Your Honor, certified copy of the lease deed. Your Honor, before the DRT, the proceedings went on. Recovery proceedings being number 2320 were started before the recovery officer, and order dated 15th June 2006 came to be passed by recovery officer for auction of the said property, Your Honor. At this juncture, Your Honor, we were not made parties, though we were in possession by GIDC. The GIDC later on sub-allotted the plot to the present appellant, Your Honor. Another lease deed came to be conveyed in my favor. Based upon that lease deed, I came into possession. After I came into possession, recovery proceedings were started before the DRT. In that scenario, Your Honor, neither I was made party of the recovery proceedings, Your Honor, but later on the appellant herein came to know about the proceedings, recovery proceedings, and the appellant herein tried to file the consent with the bank. The appellant herein was ready and willing to repay the amount of the bank, Your Honor. Despite of the consent were filed, Your Honor, to the utter shock, recovery order was passed, Your Honor, by the Honorable DRT. I was entered into possession of this property in the year of 2009 by a registered lease deed dated 7th of October 2009, Your Honor. The GIDC later on.
After proceedings started in DRT.
No, Your Honor, before that. before that. When I was taken, when the possession was transferred to me, all these proceedings was made with the permission of GIDC. GIDC itself was party in the transfer, Your Honor. Thereafter, recovery proceedings were started, and on 9th of April 2009, auction pertaining to the aforesaid property, respondent number 4 was declared as a successful auction purchaser, Your Honor. So this is the brief facts of the case, Your Honor. And since through the auction, Your Honor, the said property was transferred, and while I was in possession of the said premises, I filed a suit before the learned trial court. The suit is being special civil suit number 267 of 2012, Your Honor. Now coming to the procedure followed by the learned trial court after the suit was being filed. Till here, Your Honor, the facts was regarding the situation and status of the parties. Now coming to the facts that what procedure and what procedures were followed by before the learned trial court, Your Honor. I preferred a suit, the appellant preferred a suit.
ઓર્ડર મૂક્યો જ નથી આપેલ સમયે જો.
The appellant preferred a suit. After the filing of the suit, respondent number 3 and 4 herein, that is the bank and the auction purchaser, they moved an application under Order 7 Rule 11 below Exhibit 16 and 20, Your Honor, which is at Annexure D, Your Honor, before this Honorable Court at page number 247, if I may.
બોલ.
Yes, Your Honor. Reading the relevant portion, Your Honor, of the Exhibit 16, that is the Order 7 Rule 11 application of the respondent number 3 herein. What they had prayed for, Your Honor, briefly putting before this Honorable Court brief contentions of the respondent number 3 and the prayer which they had sought. The defendant number 3 most respectfully submits that this Honorable Court lacks jurisdiction. First, the issue of jurisdiction, power or authority to entertain and decide the present suit. The defendant number 3 further categorically submits that the claim of the plaintiff cannot be adjudicated by this Honorable Court. If this Honorable Court passes any order, it would amount to exercising jurisdiction of the Honorable Debts Recovery Tribunal of Ahmedabad. So any order is not required to be passed contrary to any of the orders passed by the Honorable DRT Ahmedabad. For all practical purposes, the Honorable DRT has already adjudicated the claims of plaintiff. The defendant number 3 further submits at page number 253, I am reading, Your Honor. The defendant number 3 further humbly submits that the Honorable Court lacks jurisdiction, power or authority to decide the present suit. The plaintiff has intentionally filed the instant suit with oblique motive and malevolent intention. Hence, the plaintiff is required to be rejected under the provisions of Order 7, Rule 11D of the Code of Civil Procedure, and exemplary costs are required to be awarded to the defendant. Hence, they prayed to reject on the ground, the plaint on the ground that the Honorable Learned Court did not have the power or did not have the jurisdiction to try the suit, Your Honor. Thereafter, at Exhibit 20, Your Honor, that is the application filed by the respondent number 4 hearing. The very same application below Order 7, Rule 11. Both of the Order 7 Rule 11 applications, that is Exhibit 16 and Exhibit 20 of the before the learned trial court, came to be rejected, Your Honor. The application under Order 7 Rule 11 of the respondents number 3 and 4 came to be rejected by the learned trial court by order dated 28/3/2013, Your Honor, which is at page number 268, Your Honor, before this Honorable Court. Annexure D calling. Reading the very operative portion, at page number 296, Your Honor, if I may. Page number 296, the last paragraph, 10th paragraph. Am I with your ladyship? Thus, as discussed above, the present suit is appearing to be maintainable qua relief prayed for in para 24A of the plaint. The learned trial court at this juncture, Your Honor, very rightly pointed out that it is maintainable but qua a particular prayer, which is at paragraph number 24A of the plaint, Your Honor. Further, hence it was held that therefore suit being maintainable in that manner, present application being not maintainable are liable to be dismissed. Here the learned trial court kept in his mind the principle of the settled position of law that the suit cannot be rejected in part. The suit cannot be rejected partially. Hence, the application of the respondents number 3 and 4 herein under Order 7 Rule 11 came to be dismissed, Your Honor. Very rightly dismissed. Thereafter, defendant number 4 herein filed application below Exhibit 41 again for review of the order. Order passed by the learned trial court below application in regards with the application below Order 7 Rule 11, Your Honor, which is at page number 298, Your Honor, before this honorable court. The review application was filed, Your Honor, by the respondent number 4 by the Exhibit 41. Therein also, Your Honor, that application also came to be rejected. The review application also came to be rejected by the order dated 17/9/2013, which is at page number 305 before this honorable court, Your Honor. Annexure E. Kohli. Reading the relevant portion of the said order dated 17/9/2013 at page number 305, Your Honor. Act 41 લગત હુકમ. Reading at paragraph number 2, Your Ladyship. મજકૂર કામે પ્રતિવાદી નંબર 3-4 તરફે મુખ્ય તકરાર એ છે કે આ કામે મારા પુરોગામી વિદ્વાન ન્યાયાધીશ આંક 16 અને 20 લગત જે હુકમ કરેલો છે તે હુકમમાં RDBF I ની કલમ 17 અને 18 ની જોગવાઈઓનું અર્થઘટન કરવામાં ભૂલ કરેલી છે તથા પ્રતિવાદી તરફે રજૂ થયેલા ચુકાદા અને વાદી તરફે રજૂ થયેલા છે તે ચુકાદા so and so ઉપરનો નલિન N.R. પટેલ તથા so and so coming to the paragraph number 4, Your Honor, at page number 308. ઉપરોક્ત બંને પક્ષની દલીલો અને પ્લીડિંગ્સને ધ્યાને લેતા સદર રિવ્યુ અરજીના નિરાકરણ માટે મારા મતે નીચે મુજબના મુદ્દા ઉપસ્થિત થાય છે. મુદ્દા નંબર 1, શું પ્રતિવાદી નંબર 3-4 પુરવાર કરે છે કે આંક 16 અને આંક 20 લગત મારા પુરોગામી વિદ્વાન ન્યાયાધીશશ્રીએ તારીખ so and so ના રોજ કરેલ હુકમ એ પુનઃ વિચારણા કરવાનો પાત્ર છે. શું હુકમ ઉપરોક્ત મુદ્દાઓના મારા નિર્ણયો નીચે મુજબ છે. The issue was answered into negative, Your Honor, by the learned trial court. Again, by the learned trial court, Your Honor, it was very rightly held at page number 320, Your Honor. I beg your pardon, at page number 319. લાઈન નંબર 7, Your Honor, પ્રતિવાદી તરફેની દલીલ હાલ ગ્રાહ્ય રાખી શકાય તેમ નથી. વાદી તરફે ઉપર ચર્ચા કર્યા મુજબના અન્ય ચુકાદાઓ રજૂ કરેલા છે તે રિવ્યુ અદાલતની સત્તા બાબતેના રજૂ કરેલા છે. જો કે તે ઓર્ડર 47 ની જોગવાઈઓ ધ્યાને લેતા તથા CPC ની કલમ 114 ની જોગવાઈઓ જોતા રિવ્યુ કયા સંજોગોમાં કરી શકાય તે અંગેની સ્પષ્ટ જોગવાઈઓ કરેલી છે તે જોતા ઉપરોક્ત ચર્ચાઓને આધારે વિગતે ચર્ચા કરેલ નથી. પરંતુ ઉપરોક્ત તમામ ચુકાદાઓ ધ્યાને લેતા અને કેસનું સમગ્ર રેકોર્ડ ધ્યાને લેતા આંક 16 અને આંક 20 લગત મારા પુરોગામી વિદ્વાન ન્યાયાધીશશ્રીએ કારણો સહિતનો જે ચુકાદો જાહેર કરેલો છે અને તેમાં કોઈ પણ પ્રકારની કાયદાકીય કે હકીકતની દેખીતી ભૂલ જણાઈ આવતી નથી. વળી બેંક તથા ઓક્શન પરચેઝર બંને સદર હાથ પરના કેસનો ન્યાયિક નિરાકરણ માટે મહત્વના પક્ષકાર છે અને તે તમામ હકીકતને લક્ષમાં લેતા હાથ પરની રિવ્યુ અરજી ગ્રાહ્ય રાખવા પાત્ર જણાતી ના હોય. મુદ્દા નંબર 1 નો નિર્ણય નકારાત્મક ઠેરવી મુદ્દા નંબર 2 પરત્વે રિવ્યુ અરજી નામંજૂર કરતો નીચે મુજબ આખરી હુકમ કરવામાં આવે છે. The review application also came to be rejected. Thereafter, respondent number 3 and 4 herein approached the Honorable High Court, challenging the order passed in the review application, Your Honor, which is at page number 321, Your Honor, before this Honorable Court. It is starting from 321, Your Honor. The relevant paragraph is at page number 338, Your Honor. I'm just reading the prayer thought by the respondent number 3 and 4 before the learned Honorable High Court. Page number 338, Your Honor. Paragraph number 6. The petitioner therefore respectfully prays as under that this Honorable Court may be pleased to issue a writ of certiorari or any other appropriate writ, order or direction in the nature of certiorari for quashing and setting aside the impugned orders passed below Exhibit 21 and 41 by the Honorable Civil Judge Gandhinagar in Special Civil Suit number 267 of 2013 and Special Civil Suit number 2026 of 2012 pending before the Honorable Civil Judge Gandhinagar be dismissed vis-a-vis petitioner. That is their prayer, first prayer. The second prayer is that pending admission, hearing and final disposal of the present petition, the Honorable Court may be pleased to stay the operation, implementation and execution of the impugned orders passed by the Honorable Court below Exhibit 20 and 41 in the Special Civil Suit number 267 of 2012 and stay further proceedings of the said suit, Your Honor. These are their prayers. They wanted to delete themselves as parties since they were not concerned. And their contention was that the learned trial court did not have jurisdiction, Your Honor. Thereafter, Your Honor, when this petition was filed before the Honorable High Court, Your Honor, at page number 367, Your Honor, that is the order. It's page number 367, order of the High Court. Mr. Raval, learned advocate, has waived service of rule for the respondent number 1, qua rest of respondents direct services permitted. Simply, rule was issued, Your Honor, by the Honorable High Court. This order date is important to be taken into consideration. The date is 22nd of April 2014, Your Honor. Thereafter, there was no stay, Your Honor. This is very relevant. There was no stay by the Honorable High Court. And the suit was at the stage of hearing of the application below Exhibit 5, Your Honor. That is for temporary injunction, Your Honor. At that point of time, Your Honor, defendant number 3 and 4 moved an application for adjournment, which ultimately came to be granted by the learned trial court. And against such order of grant of adjournment, the plaintiff herein preferred another SCA before the Honorable High Court, Your Honor. At this juncture, it is most relevant to point out, Your Honor, that the appellant herein had preferred an application. The appellant herein had preferred an application before DRT for modification or rectification of the order passed by the DRT, Your Honor, dated 24th May 2005, Your Honor, which ultimately reached up to the Honorable Supreme Court, Your Honor. The appellant herein approached the Honorable Supreme Court, Your Honor, for modification or rectification of the order passed by the DRT of the auction purchaser that such and such person is the auction purchaser of the suit premises. That order was requested to be modified by the present appellant herein, which ultimately reached up to the Honorable Supreme Court, Your Honor. Now coming to page number 370, Your Honor. 370. That is the order dated 11th of September 2017, passed by the Honorable Supreme Court, which is produced before this Honorable Court. The relevant portion is at page number 371, Your Honor. That is the order of the Honorable Supreme Court, Your Honor. Reading from line number 2, Your Honor. We have been informed that a civil suit between the parties is pending, in which an application under Order 7, Rule 11 has been dismissed. However, appeal filed against the said order is pending. Mr. Banerjee, learned senior counsel, very fairly concedes that he will withdraw that appeal so that the suit may otherwise be disposed of. Now the relevant portion begins, Your Honor. The status quo order that we have granted will continue for a period of 1 week from today. The status quo even was granted by the Honorable Supreme Court, though for a very short period of time, Your Honor. In the event that it is possible for the petitioners to apply for the interim orders, I was the petitioner before the Honorable Supreme Court, Your Honor. In the event that it is possible for the petitioners to apply for interim orders in the suit, they may do so. The suit will be heard on all issues, including preliminary issues. This is very much important to be considered, Your Honor. All issues, including preliminary issues that have been taken by Shri Banerjee's client, including jurisdiction, Your Honor. I was given liberty to file for the interim order to seek any kind of interim relief. Again, the respondent herein was also given liberty to raise their preliminary issues, Your Honor. And after deciding those preliminary issues, the trial court was supposed to proceed with the suit and grant or not grant the interim relief, Your Honor. Thereafter, the appellant moved an application before the trial court for mandatory injunction below Exhibit 43, Your Honor. The order of which is challenged before this Honorable Court, Your Honor. That application was moved by the appellant hearing merely for mandatory injunction by the Exhibit 43, Your Honor. Thereafter, hearing all the parties, learned trial court rejected the application below Exhibit 5 and 43, Your Honor. Not only that, very surprisingly, the trial court held that the suit is not maintainable for defendant number 3 and 4. The trial court neither framed preliminary issues, Your Honor. The trial court not given any preliminary satisfaction in its order, Your Honor. At the stage of hearing of the interim applications, the trial court very surprisingly dismissed the suit for defendant number 3 and 4, Your Honor, which is the order in challenge before this Honorable Court, Your Honor. Before moving further, Your Honor, I would like to point out the relevant portions of the impugned order, Your Honor, at page number 120, Your Honor, of the annexures. The impugned order is dated 9th of March 2018, Your Honor. Reading only the relevant portions, Your Honor. At paragraph number 4, internal page number 3 of the order, Your Honor, impugned order. Am I with your ladyship? At paragraph number 4, the defendant number 3, bank has filed its reply by Exhibit 17, wherein it has denied almost all material allegations, statements, and averments made by the plaintiff in such application at Exhibit 5. The defendant bank has challenged the jurisdiction of this court to try, hear, and decide the present suit in view of the provisions of Section 17, 18, and Section 34 of the Recovery of Debts Due to Banks and Financial Institution Act. the defendant bank has also challenged maintainability of the case of the plaintiff under the principles of res judicata and averred that as regular civil suit number so and so as well as regular civil suit number so and so came to be filed by the predecessor in title of plaintiff as well as by defendant number 5 wherein the suits were filed on the same cause of action of the present suit. The defendant bank has also challenged the suits as well as this application of the plaintiff under the law of limitation by averring that since any cause of action, if at all, arose to file the present suit, the same arose not later than the date 9th of April 2009 or from the date when the regular civil suit number 58 of 2006 came to be filed. Moving further at paragraph number 5, Your Honor, internal page number 5 of the order, Your Honor. Defendant number 4 has filed her written statement while exhibit 21 wherein she categorically denied almost all material facts of it and inter alia contended that this court has no jurisdiction to try, hear and decide the present case under section 17 read with section 18 of the RDBF I Act. Their main contention while hearing or while arguing the application for interim orders, Your Honor, was the maintainability, Your Honor. That was taken into consideration by the learned trial court, which again is not permissible in the eyes of law. Now, the contention which the appellant took before the learned trial court at page number 7, Your Honor. I beg your pardon, at page number 9, paragraph number 7. The very last line of the 9th page. It is further argued that issue of jurisdiction is already decided by this court by common order passed in an application at exhibit 16 and exhibit 20, Your Honor. Your Honor, their application below order 7 rule 11 came to be rejected. Their review application also came to be rejected, Your Honor. Their special civil application before the Honorable High Court came to be withdrawn since they were deleted as parties by this order, Your Honor. Next, what are contention at page number 10, Your Honor. Page number 13, paragraph number 10. The issues framed. Very interesting to be taken into consideration. The issues framed by the learned trial court. What are the issues framed, Your Honor? Considering pleadings of either sides, following points have arisen for final determination of this application. The first issue framed by the learned trial court is very interesting to be looked into, Your Honor. Whether this court has jurisdiction to try, hear and decide the present suit. Your Honor, this is the issue framed by the learned trial court by deciding the interim application, Your Honor. This was not the preliminary issues which were being decided. This was the interim application seeking mandatory and temporary injunctions by the plaintiff. Was this issue, I'm putting a question to myself, Your Honor. Was this issue correctly framed primarily? The answer is negative, Your Honor. At paragraph number 11, Your Honor, the answer to issue number 1 in negative with respect to defendant number 3 and 4. Your Honor, this is a very settled position of law that a suit cannot be rejected in part. Neither a single prayer can be kept and other prayer may be dismissed, nor it is permissible that some of the defendants are deleted or the suit is dismissed qua some of the defendants. This is clearly impermissible in the eyes of law, Your Honor. Now, reading the relevant portion, the reasoning given by the learned trial court at page number 14, Your Honor. It appears from the chronology of events that the partner of Messrs. Standard Ceramics availed financial assistance from defendant number 3 bank and with a view to secure a due repayment also deposited second copy of lease deed with defendant number 3, Your Honor. The learned trial court was very well within the knowledge that the copy produced before the bank was the second copy and not the original lease deed, Your Honor. Moving further at paragraph number B, Your Honor, page number 14. Messrs. Standard Ceramics committed default in such repayment and therefore defendant number 3 filed special civil suit number so and so against the said firm, and Messrs. Standard Ceramic was injuncted from transferring the said plots to anybody, and this order came to be confirmed on dated 8th of February 1993. The said suit came to be transferred to DRT and was registered as transfer application number 421 of 1995. Messrs. Standard Ceramics informed defendant number 1 to transfer the said plots in the name of Mr. Sainani as sole proprietor of it, who made a request along with undertaking dated 12th of June 2003 to pay back the dues of defendant number 3 bank. The defendant number 1 transferred the said suit plots in favor of Mr. Harishchandra Sainani, subject to the aforesaid undertaking, Your Honor. The DRT on dated 24th of May 2005 issued recovery certificate against Messrs. Standard Ceramics, upholding the mortgage of defendant number 3 bank and also given liberty to attach the said suit properties, Your Honor. Said suit plots, Your Honor. Now coming to paragraph number D, on the next page, Your Honor. The plaintiff also furnished similar undertaking. The plaintiff is the appellant, Your Honor. The plaintiff also furnished similar undertaking and undertook to pay whatever the dues of defendant number 3 bank, wide mark number 22/2, 22/3 and 22/4. The plaintiff admitted the mortgage of defendant number 3 over the suit plots by her letter dated 26th of 11, 2008, produced wide mark 22/14, Your Honor. Again, Your Honor, the learned trial court was very well within the knowledge that I was ready to repay the amount of the bank, which was admittedly due, Your Honor. The undertaking filed by the plaintiff, the appellant herein, was also produced before the learned trial court, Your Honor. Moving further at paragraph number F, Your Honor, of page number 15. The plaintiff also approached the bank, that is defendant number 3, for settlement of dues, wide her letter dated 26/11/2008, produced wide mark 71/1. Thereafter, this is very much relevant, Your Honor, thereafter consent terms came to be fixed in between plaintiff and defendant number 3 as appears wide mark number 71/2. There was consent terms, Your Honor, which was entered into between the appellant and the bank. Those consent terms was also produced before the learned trial court. Thereafter, the plaintiff deposited, I have also deposited rupees 31 lakhs and 50,000 in favor of the bank, but thereafter wrote a letter wide mark number 71/8 and 71/10 and withdrawn such consent fixed in between the parties. Your Honor, the relevant fact which needs consideration is that I had not withdrawn the said amount. If I had to withdraw, at the first place, I would not have deposited, Your Honor. I had admitted, I had kept the undertaking. Also, I had deposited the said amount before the bank. But what bank, or rather what DRT did, was sold the suit property into auction. My money was gone, Your Honor. The suit plot was also gone to some other auction purchaser, Your Honor. Hence, I withdraw the said amount, Your Honor. There was settlement talks between the bank and the plaintiff hearing. Though the DRT passed an order, DRT was also well within the knowledge that consent terms was filed. And consent terms, the written consent terms was also produced before DRT. And without taking that into consideration, the DRT ordered for the auction of the said suit property, and hence we went up to Supreme Court. Therein, the Supreme Court said that let the trial court decide the issue. Now, all the burden to decide the rights and liabilities of the each and every party was upon the learned trial court, Your Honor. Thereafter, coming to paragraph number 12.1 herein, Your Honor, of the impugned order, page number 16. 12.1. Issues were, the reasonings, point-wise reasoning was given by the learned trial court. Now in reading paragraph number 12.1, Your Honor, now in view of the aforesaid undisputed facts that the controversy between the parties with respect to interim injunction application at Exhibit 5 be decided on merits. Point number 1. The learned advocate of defendant number 3 and 4 have challenged jurisdiction of this court under section 17 read with section 18 of recovery of debts due to bank and financial institution. Your Honor, this issue was already decided. While the learned trial court decided the application below order 7 rule 11, Your Honor. If this issue was to be reconsidered, preliminary issues were to be framed, Your Honor. Those preliminary issues were to be decided primarily, and thereafter this application should have been heard. Despite of the liberty given by the Honorable Supreme Court to the respondents, Your Honor, they neither have given their preliminary issues before the learned trial court, nor trial court have so modo given any preliminary issues, Your Honor. Hence, this issue at the stage of deciding of the injunction application is very irrelevant. And hence I am praying before this honorable court to caution set aside the impugned order, Your Honor. Now coming to the operative part of the order, Your Honor. At page number 41 of the impugned order, internal page number 41. The application-wide exhibit 5 and 43 of plaintiff are hereby dismissed with cost. It is further held that this civil court has no jurisdiction. Again, issue of jurisdiction is being decided in the application for injunction. It is further held that this civil court has no jurisdiction to entertain suit of plaintiff. Again, non-application of mind by the learned trial court that with respect to defendant number 3 and 4. Either the learned court ought have rejected the whole plaint, or have not rejected, dismissed the suit qua defendant number 3 and 4. Since partial rejection of the suit is not permissible, Your Honor. Hence, there are 5-6. My preliminary, there are 5-6 grounds, Your Honor. First is that civil court has jurisdiction to hear the suits. Coming to that, Your Honor. Coming to that part, Your Honor. On what grounds my present appeal may be allowed by this honorable court? That is my humble submissions, Your Honor. I am putting before this honorable court. The first ground taken by the respondents, rather on which the learned trial court relied upon, that the civil court did not have jurisdiction. Your Honor, my submission is that. Just a moment. Your Honor. I'm producing a set of judgments, Your Honor.
Authority.
Yes, Your Honor. Authorities. I have produced authorities basing upon the grounds on which I am relying upon. There are 4 sets produced before this honorable court. Hence, since I'm relying upon 4 major grounds, Your Honor, and the sets are according to the grounds, Your Honor. Coming to the first ground, that the civil court has jurisdiction. Now they had relied upon, the respondent number 3 and 4 had relied upon section 17 and section 18 of the RDBF Act, Your Honor. At this juncture, it becomes most relevant to take into considerations of section 17 and section 18, Your Honor, of the 1983 Act. What section 17 states about? Jurisdiction, powers and authority of tribunals. A tribunal shall exercise on and from the appointed day, the jurisdiction, power and authority to decide and to entertain and decide applications from the banks and financial institutions for recovery of debts due to such banks and financial institutions. The DRT was given power, Your Honor, to entertain and decide applications only and only of the banks and financial institutions. I, having the civil rights over the suit property, had no power, had no right to go before the DRT, Your Honor. My civil rights can only be decided by a civil court, Your Honor. Section 17 of the 1983 Act gives power to the DRT to try to entertain and decide the suits, decide the applications from the banks and financial institutions. No other person can go before the DRT and seek relief. The DRT has just powers to give relief to the banks and the financial institutions. First and foremost, I am neither a bank nor a financial institution. Hence, I cannot go before the DRT, Honor. I can only claim my civil rights before a civil court, Your Honor. Now, coming to section 18 of the said Act, Your Honor, bar of jurisdiction. On and from the appointed day, no court or other authority shall have or be entitled to exercise any jurisdiction, powers or authority in relation to the matters specified in section 17. Section 18 gave bar of jurisdiction to other authorities and other judicial or quasi-judicial authorities, Your Honor. But in relation of what? In relation to section 17, Your Honor. In what section 17 says that DRT has just jurisdiction to entertain and decide the application of banks and financial institutions. If a bank and financial institution has to seek relief, then it has to go before the DRT and no other authority has power to entertain and decide such application. On the other hand, Your Honor, except the banks and financial institutions, the DRT has no powers. The DRT can only entertain and decide the suits of banks and financial institutions. What the third parties can seek, again a question putting to myself, Your Honor, can a third party seek relief before DRT? Since there was no issue of debt, Your Honor, DRT has been established just to recover the debts from the borrowers and give it back to the banks or the financial institutions. There was no issue of debt as such. I am concerned, Your Honor. Now what I am seeking is my civil rights, Your Honor, since I was transferred the said suit property by registered lease deed and also from and with the permission of GIDC, which is the original owner, Your Honor. Such issue can only be decided by the civil court and not by the DRT, Your Honor. That is my first and foremost submission, Your Honor. The very first judgment, the authority which I am citing before this honorable court is of Supreme Court, Your Honor, Nahar Industrial Enterprises Limited versus Hong Kong and Shanghai Banking Corporation. Am I with your ladyship? Yes. Just reading the relevant portion, Your Honor, at internal page number 32 of the said authority, Your Honor. This is the judgment passed by the Honorable Supreme Court in the year of 2009, Your Honor. What the Supreme Court has to say in respect of such issues. Page number 32, Your Honor, paragraph number 105. The civil court indisputably has the jurisdiction to try a suit. If the suit is vexatious or otherwise not maintainable, action can be taken in respect thereof in terms of the court. But if all suits filed in civil courts, whether inextricably connected with the application filed before the DRT by the banks and financial institutions are transferred, the same would amount to ousting the jurisdiction of the civil courts indirectly. Suits filed by the debtor may or may not be counterclaims to the claims filed by the banks or financial institutions, but for that purpose, consent of the plaintiff is necessary, Your Honor. Reading ahead, Your Honor, paragraph number 106. It is furthermore difficult to accept the contention of the respondents, that which is also the contention of the present respondents, Your Honor. It is furthermore difficult to accept the contentions of the respondents that the statutory provisions contained in section 17 and 18 of the DRT Act have ousted the jurisdiction of the civil court, as the said provisions clearly state that the jurisdiction of the civil court is barred in relation only to applications from the banks and financial institutions for recovery of debts due to such banks and financial institutions. This makes it very clear that the civil court has all the rights to entertain and decide the suits filed by a third party. I am the third party, Your Honor. I'm neither the debtor, I'm neither the borrower, I'm neither any bank nor a financial institutions. Hence, the civil court has the right. The section 17 and section 18 of the DRT Act does not bar the civil rights of the third parties. In fact, it does not bar the civil rights of the debtors, Your Honor. The debtors could even go before the civil court and ask their relief. Whether they want to file their counterclaim or not before the DRT, they still have the debtors still have the liberty to go before the civil court, Your Honor. Further, a civil court is entitled to decide the respective claims of the parties in a suit. It must come within the purview of the hierarchy of courts as indicated in section 3 of the code. It will have jurisdiction to determine all disputes of civil nature, unless the same is barred expressly by a statute or by necessary implication. Although some arguments have been advanced before us, whether having regard to the provisions of section 17 and 18 of the Act, the civil court jurisdiction is completely ousted. We are of the view that the jurisdiction of the civil court would be ousted, but only in respect of the matters contained in section 18, which has a direct correlation with section 17 thereof. That is to say that the matter must relate to a debt payable to a bank or a financial institution. The application before the tribunal would lie only at the instance of the bank or financial institutions for the recovery of debt. It must further be noted in this respect that had jurisdiction of the civil courts been barred in respect of counterclaim also, the statute would have said so, and section 17 and 18 would have been amended to introduce the provision of the counterclaim. We may in this context place on record the following observations from the Indian Bank, which are the same contentions of the respondent here, in Your Honor. Section 9 of the Code of CPC provides that the courts shall have jurisdiction to try all suits of a civil nature, excepting the suits of their cognizance is either expressly or impliedly barred. It is evident from section 17 and 18 of the DRT Act that civil court's jurisdiction is barred only in regard to the application by a bank or a financial institution for recovery of a debt. the jurisdiction of civil courts is not barred in regard to any suit filed by a borrower or any other person against a bank or any relief. The position of law is very settled and very clear, Your Honor, that the jurisdiction of a civil court is not barred in regard to any suit by a borrower or any other person, Your Honor. Looking to the facts, I am the third party, Your Honor. I have not taken mortgage. I am not the borrower, neither I am the financial institution or a bank. Hence, the suit filed by the present.
Plaintiff has accepted liability of
Yes, Your Honor.
defendant number 3
Yes, Your Honor.
and
But
then
I was,
withdrawn.
yes, Your Honor, but I was not the original borrower.
But why the consent has been withdrawn?
Because despite of the consent which was filed
What was the amount actually payable?
with 31,
That is paid by plaintiff.
yes, Your
But
Honor.
what was the amount, actual
That
amount?
was the amount, Your Honor. The whole amount
Only
was
31.
31 lakhs 31 lakhs 50,000 something, Your Honor.
As per plaintiff statement, 31 lakhs is due.
Yes, Your Honor. I had paid, but I had also kept the consent terms before the Honorable DRT. Despite taking that into consideration, the DRT ordered for the auction, and hence I went up to the Supreme Court in regard with the modification and rectification of the order passed by the Honorable DRT. When I went to the Supreme when I approached the Honorable Supreme Court, the Honorable Supreme Court has directed the learned trial court to decide the issues. Your Honor, hence my hands were tied. If the issue was decided before the Supreme Court, the suit itself would have become infructuous, Your Honor. But rather, Supreme Court has directed the learned trial court to decide all the rights and liabilities of all the parties, Your Honor. Moving further at paragraph number 113, Your Honor, page number 34 of the same authority. For the sake of the argument, Your Honor, considering I am a borrower, since I had accepted the loan amount and admitted the mortgage, Your Honor, considering that I am for the sake of argument, that I am a borrower, Your Honor, in that case also, the civil court jurisdiction is not barred, Your Honor. The civil court jurisdiction is only barred when a bank or a financial institution has to recover its amount. Neither it was the issue of recovery, Your Honor, since I had already deposited the said amount. The only issue which was to be decided was my civil rights. As I was in possession before the auction, Your Honor, as I had the original lease deed, I was the registered lease deed, I was the lessee, Your Honor. Without taking that into consideration and to protect my civil rights, I had come before civil court, Your Honor. Hence, the civil rights can only be decided by a civil court, Your Honor. That is my humble submission before this honorable court. Which is coming now, Your Honor, at paragraph 113, Your Honor, of the same authority at page number 34. In Nagri Pracharini Sabha versus 5th Additional District and Sessions Judge, it was held that a litigant having a grievance of a civil nature has independently of any statute a right to institute a suit in the civil court unless its cognizance is either expressly or impliedly barred. The position is well settled that exclusion of jurisdiction of the civil court is not to be readily inferred, and such exclusion must be either expressly or impliedly barred, Your Honor. Since I was seeking before that, Your Honor, the prayer which I had sought in my claim, Your Honor. Let's look into that, Your Honor. The prayer which I had sought. The nature of the prayer which I had sought, whether it was regarding in civil nature or whether it was regarding the recovery of debts or whatever, Your Honor. At page number 49 of the annexures, Your Honor. This is my prayer of the plaint, which will describe the nature of the suit, Your Honor. At page number 49 of this annexures before this honorable court, relief. First, A, that this honorable court be pleased to pass a decree in favor of the plaintiff by declaring that we, the plaintiffs, are the sole and lawful occupant and possessor of the suit property as described in para 1 of the said suit, and it also be further declared that the registered deed executed by defendant number 1 in this matter in favor of the plaintiff dated 7th of October 2009 is legal and valid. I am seeking declaratory relief, Your Honor, to declare that I am the sole and lawful occupant and the possessor of the suit premises. Secondly, what I have prayed before the learned trial court was that since we the plaintiffs are having lawful possession, right and interest in the suit property, this honorable court be pleased to issue permanent injunction in favor of the plaintiff and against the defendants in this matter or their agents, servants, associates, restraining them from creating objection or hindrance in the possession and occupation of the plaintiffs in reference to the suit property. Majorly, I had two prayers before the learned trial court. First, relief in the nature of declaration. Second, relief in the nature of injunction, Your Honor. I may not be dispossessed without following due process of law, Your Honor. That was my simple prayer, which is nothing but a prayer in the nature of civil, Your Honor. Protecting my civil rights, Your Honor. Coming back to the authorities, Your Honor. At paragraph number 117, page number 34 of the same authority, Your Honor. The act, although was enacted for a specific purpose, but having regard to the exclusion of jurisdiction,
Yes.
page number 34 of the authority, Your Honor, paragraph number 117. The act, although was enacted for a specific purpose, but having regard to the exclusion of jurisdiction, expressly provided for in section 17 and 18 of the act, it is difficult to hold that a civil court's jurisdiction is completely ousted. Indisputably, the banks and financial institutions, for the purpose of enforcement of their claim for a sum below 10 lakhs, would have to file civil suits before the civil courts. It is only for the claims of the banks and financial institutions above the aforementioned sum that they have to approach the DRT. It is also without any cavil that the banks and financial institutions, keeping in view the provisions of section 17 and 18 of the Act, are necessarily required to file their claim petitions before the tribunal. The converse is not true. Debtors can file their claims of set-off or counter-claims only when a claim application is filed and not otherwise. Even in a given situation, the banks and or financial institutions can ask the tribunal to pass an appropriate order for getting the claims of set-off or the counter-claims determined by a civil court. The tribunal is not a high-powered tribunal. It is a one-man tribunal. Unlike some special acts, as for example, Andhra Pradesh Land Grabbing Prohibition Act, it does not contain a deeming provision that the tribunal would be deemed to be a civil court. if one have to seek relief in the nature of civil relief, it has to go before a civil court. The DRT cannot decide my civil rights. Hence, I came before the learned civil court. And time and again, Honorable Supreme Court, Honorable High Court has time and again very categorically specified and made a very settled position of law that when a borrower or any other person or a third party seeks its civil right, the civil courts has all the jurisdictions to try such suits and decide it finally, Your Honor. Hence, it was wrongly held by the learned trial court that the trial court did not had the jurisdiction to entertain and decide the suit again qua some of the defendants, that is the bank and the auction purchaser, Your Honor. Coming to the next authority, Your Honor. That is the judgment passed by the Honorable Gujarat High Court in the year of 2010. Nalini Ben Rajnikant Patel through power of attorney versus Rashmikant Manubhai Amin. Paragraph number 11, page number 3 of the said authority, Your Honor. Internal page number 3, Your Honor. Paragraph number 11, Your Honor. In the present case, the only question required for determination is whether the suit filed by the petitioner, original plaintiffs, is barred under Section 18 of the Recovery of Debts Due to Banks and Financial Institution Act, Your Honor. This is the very same question which has to be decided by this Honorable Court, Your Honor, which was already decided by the Honorable Gujarat High Court. If I may be of some assistance, Your Honor. Reading paragraph number 2, page number 4 of the said authority, Your Honor. Internal page number 4, paragraph number 12. Section 17 of the RTBI Act relates to jurisdiction, powers and authority of the tribunals to entertain and decide applications from the banks and financial institutions for recovery of debts due to such banks and financial institutions. Under Section 18, there is a bar on jurisdiction of all other courts except the Supreme Court and the High Courts exercising jurisdiction under Article 226 and 227 of the Constitution to exercise any jurisdiction, powers or authority in relation to the matter specified in Section 17. That means there is a bar on civil courts to entertain such applications on behalf of the banks and financial institutions for recovery of debts due to such banks and financial institutions. The bar is only limited to the applications by the banks and financial institutions and not otherwise, Your Honor. Reading further at page number 5, paragraph number 14. Page number 5, paragraph number 14, Your Lordship. In the present case, the plaintiffs have prayed for reliefs, English version of which are quoted hereunder. Your Honor may be pleased to declare that 3 movable properties, namely 1, 2 and 3, I am not going into the description of the property, Your Honor, lying in the said properties are ancestral joint properties of the plaintiffs and defendant number 1, 2 and 4 to 8, and also declare that in the suit properties there is a share, right and title of plaintiffs, and declare that defendant number 3 and 4 have no right to disturb the right of the plaintiffs in the aforementioned properties. The relief sought by in the said in that respective suit is very similar to the relief which I am claiming before the learned trial court. Now, what the Honorable High Court said while deciding the said issue at paragraph number 15, Your Honor, page number 6. The first portion of the prayer made in para 12A aforesaid relates to a declaration that the plaintiffs and the concerned defendant number 1, 2, and 4 to 8 have shares, rights, and title on the suit properties in question. The bank cannot file any application under section 17 for such declaration, nor the DRT can entertain or decide such applications under section 17 of the RDBI Act, Your Honor. In view of such prayer made in the first portion of para 12A of the plaint with regard to declaration of share, right, and title, in view of section 17 of the Act and the decision of the Supreme Court in the Nahar Industrial Enterprises versus Hong Kong and Shanghai Bank Corporation and referred to above, we hold that the Debt Recovery Tribunal has no jurisdiction, power, and authority to entertain and decide the aforesaid issue, either at the instance of the bank or the petitioner, Your Honor. Original plaintiffs. The learned 7th Additional Senior Civil Judge Vadodara and the appellant court in Civil Miscellaneous Appeal number so-and-so odd in holding that the total suit, including the relief sought for in the first portion of para 12A relating to the declaration of share, title, and interest in the suit properties is barred under section 18 of the Act, Your Honor, which again makes it very clear that the civil court has all the jurisdiction, all the powers to decide my civil rights, to decide or to declare whether I have share, right, or title in the suit property or not, Your Honor. That only a civil court can decide, not the DRT, Your Honor. Hence, the suit was also maintainable qua defendant number 3 and 4. Moving further, coming to the next authority, Your Honor. Moving to the next authority. Again, a Supreme Court judgment 2006, Your Honor. Internal page number 7 of the said judgment, Your Honor. Paragraph number 14. Am I with my lips? It is evident from section 17 and 18 of the Debts Recovery Act that civil court's jurisdiction is barred only in regard to applications by a bank or a financial institutions for recovery of its debts. The jurisdiction of civil courts is not barred in regard to any suit filed by a borrower or any other person against a bank for any relief. Civil court again very clearly stated by the Honorable Supreme Court in this authority, Your Honor. Civil court had all the jurisdictions to decide my rights, which were in the nature of declaratory relief and injunctory relief, which can only be decided, for the sake of repetition, Your Honor, which can only be decided by a civil court and not by the DRT. Hence, the suit was very well maintainable. The suit cannot, I will be coming to the next round, that the suit cannot be rejected into part. When it is decided that the suit is maintainable, after that it cannot be dismissed or rejected for some of the defendants, Your Honor. I will lead my on a later stage, Your Honor. Moving to the next authority, Your Honor. Again, a Supreme Court judgment of 2003. At page number 7, internal page number 7 of the said judgment, Your Honor, paragraph number 18. The learned senior counsel for the appellant has made several submissions which cannot be grouped into three. Which can be grouped into three. First, that the civil court did not have jurisdiction to try the suit and the plaintiff should have been relegated by the trial court to pursue his remedy before the authority or tribunal competent to adjudicate upon such dispute under the provisions of the such and such act, which is the relevant portion in relation to the facts, when the facts of the present case is considered, Your Honor. Coming to paragraph number 19, we find, as would be dealt with hereinafter, the first two pleas devoid of any merit, but partial merit in the last plea. As to the first submission, we find that the civil court does not suffer from any inherent lack of jurisdiction. Where there is a special tribunal conferred with the jurisdiction or exclusive jurisdiction to try particular class of cases, even then the civil court can entertain a civil suit of that class on availability of a few grounds. An exclusion of jurisdiction of civil court is not to be readily inferred, Your Honor, which needs to be taken into consideration and which is again my humble submission before this honorable court. Again, moving to the next authority, Your Honor.
બાકી રાખીએ ત્યાં. બાકી રાખીએ ત્યાં.
Please, Your Honor. If my ladyship may spare 10 minutes, I would wind it up. I
Because
request.
you are reading entire authority.
I will not. I will not. I will take hardly 10 minutes from now. Please, Your Honor. My first ground that the civil court has jurisdiction, I had placed before this honorable court my humble submissions and the authorities before this honorable court. Coming to the second ground, which I have taken in the present appeal, is that the plaint cannot be rejected in part. What the trial court did was to reject my plaint in part, Your Honor, since it dismissed the suit for defendant number 3 and 4. I will cite only one authority before the head note to be taken into consideration. The first authority of Supreme Court 2023, Your Honor. Rejection. The heading would be judgments on plaint cannot be rejected in part.
Name.
Gita was daughter of late Krishna versus the very first authority, Your Honor. The very first authority, Your Honor. I would briefly.
First is Nahar.
That is ground wise, Your Honor. The set is ground wise. That ground has been completed from my side. Moving to the second ground, that is the ground that the plaint cannot be rejected in part.
Gita Bhatt.
The very first authority, Supreme Court Judgment 2023, Gita, daughter of late Krishna versus Nanjuda Swami. Am I with my ladyship? Just reading one paragraph, Your Honor. Very first page, paragraph B, head notes, rejection, CPC Order 7 Rule 11, rejection of plaint. Scope of, in an application under Order 7 Rule 11, CPC, a plaint cannot be rejected in part. True test is first to read the plaint meaningfully and as a whole taking it to be true. Upon such reading, if plaint discloses a cause of action, then application under Order 7 Rule 11 must fail. Just paragraph number 11, Your Honor, page number 6. There is yet another reason. Am I with my ladyship? Paragraph number 11, page number 6, internal page number 6. There is yet another reason why the judgment of the High Court is not sustainable. In an application under Order 7 Rule 11, a plaint cannot be rejected in part. This principle is well established and has been continuously followed since the 1936 decision in Maqsood Ahmad versus Matra Dutt, wherein it was decided that we do not deem it necessary to elaborate on all other arguments as we are inclined to accept the objection of the defendant, of the appellant, that the relief of rejection of plaint in exercise of powers under Order 7 Rule 11D cannot be pursued only in respect of one of the defendants. Reading again that, Your Honor, we do not deem it necessary to elaborate on all other arguments as we are inclined to accept the objection of the appellant that the relief of rejection of plaint in exercise of powers under Order 7 Rule 11D cannot be pursued only in respect of one of the defendants. Your Honor, hence trial court made a huge error by dismissing my suit, by rejecting my suit partially, by dismissing the suit qua defendant number 3 and 4. I'm not going into all the judgments due to the difficulty I can understand, Your Honor. Moving to my next ground, Your Honor. My first ground was that civil court has all the jurisdiction, has all the powers to entertain my suit. When it is decided that the civil court has jurisdiction and powers, it cannot reject my suit partially by dismissing the suit qua defendant number 3 and 4, Your Honor. This is my respectful submission. Moving further, considering that the suit is maintainable, and these are rather the merits which has to be placed before the learned trial court. But my another submission is that not a valid mortgage was produced before the bank, Your Honor. Why the order of DRT cannot be taken into consideration, and why the civil court has all the powers to protect my civil rights, Your Honor. Firstly, that there was not a valid mortgage. Taking into consideration section 58F of the Transfer of Property Act, Your Honor, when a borrower has to mortgage a property, he has to produce the original deed before the bank. The trial court was well within the knowledge that the second copy of the lease deed was produced before the bank. Again, admittedly, by the respondent number 3 and 4, second copy was kept before the bank. Hence, my next round is that the auction which took place has to be null and void, since there was no valid mortgage as per section 58F of the Transfer of Property Act, Your Honor. For that, only one judgment I would like to put before this honorable court, Your Honor. Gujarat High Court Judgment 2011, Your Honor. Pranjivan Parshuttam Zaveri versus Dena Bank, at page number 10, Your Honor, paragraph number 17. Just one paragraph I would like to. Page number 10, paragraph number 17, Your Honor. It is true that the Securitization Act is enacted to provide a speedy and summary remedy for recovery of thousands of crores which were due to the banks and financial institutions. But at the same time, if prima facie there appears to be a case of fraud, then persons like the present petitioners also deserve some protection at the hands of the court. And it cannot be said that by affording such protection in given set of evidence, the very object of the act is defeated. Justice cannot be done by doing injustice with someone, Your Honor. If I had to seek my civil rights, before whom I had to go? Only civil court, Your Honor. Forgetting all the authorities, Your Honor, in the dispute between the same parties, Your Honor, Supreme Court has directed the learned trial court to decide the issues. In fact, it is the contempt of the order passed by the Honorable Supreme Court, Your Honor. When Supreme Court has very specifically and categorically ordered that the trial has to be decided, firstly, the preliminary issues has to be decided, including jurisdiction. Very specifically, Honorable Supreme Court has mentioned. Despite of that, learned trial court has made a huge error of law, Your Honor. Hence, the impugned order needs to be quashed and set aside. This is my humble prayer, Your Honor. Last submission before this honorable court, that when the mortgage was taken, Your Honor, in the lease deed, there are clause called 2R clause, wherein the lease deed between the original allotee, that is Harish Chandra Messrs. Standard Ceramics, Your Honor. In that lease deed, Your Honor, it was very specifically and categorically mentioned that if the allotee has to mortgage the property, it has to be done with the permission of the GIDC. In this case, Your Honor, admittedly, no permission has been taken. No permission of GIDC was taken. Rather, GIDC was not within the knowledge of such mortgage, Your Honor. All such, the mortgage was also a fraud on part of the original borrower. Our bona fide to keep the possession was that despite of whatever the original borrower did, we accepted his dues, Your Honor. We accepted his dues to just to show our bona fide and just to protect our civil rights, Your Honor. We also deposited the amount as produced before this honorable court, Your Honor. Hence, the impugned order is bad in the eyes of law, Your Honor, and I request before this honorable court to caution set aside the impugned order, Your Honor, and allow the present appeal. I'm highly obliged, Your Honor.
Defendant માં કોણ છે? Defendant માં કોણ છે? Respondent માં. તો કાટ કરી લો. Proxy આપી. આવી ગઈ ને?
વકીલ શ્રી બી આર શર્મા.
First-
વકીલ શ્રી બી આર શર્મા. વકીલ શ્રી બી એસ સિંહ. બી એસ સિંહ. બી એસ સિંહ.
30/11.
વકીલ શ્રી વી એસ સિંહ. વકીલ ડીડી ચૌહાણ. વકીલ શ્રી ડીડી ચૌહાણ.
અમને સાંભળવા હો. Respondent શું? નિશાંત તમને છોડી મૂક્યા, કેસ પૂરો થઈ ગયો. નથી નિશાંત તો નથી બેસાડ્યા.
નિશાંત ઉર્ફે ભૂકો.
નિશાંતભાઈ તમને છોડી મૂક્યા, કેસ પૂરો થઈ ગયો. જામીન આપવાના થશે એના વકીલ જે એમ શુક્લ. પ્રિન્ટ પણ નથી મારી સાવ આવું પેજ નથી બદલી ગયા ને બે જ આવી જ ને હજી તો બે જ આવી છે ઓલો વાળી. ખાલી શાંતિ બોલો. એમાં આવી ગયું ને એફિડેવિટ
હા 979 ને
ફૂલ
સારે આજે HM સુરતી
નોટિસ ઇસ્યુ થઈ ગઈ હતી એટલે એમનું વ્યક્તિ આવી ગયું.
બચી ગયું છે?
વકીલ HM સુરતી
બોલો. એફિડેવિટ કે એ તો એફઆઈઆર છે. બોલો.
Please. So, sir, by lodged under the 307-232-504-114 of Indian Penal Code and Arms Act 25B, 25(1)B and 27. My lords may kindly see the FIR on page number 3. I just read the only relevant point, my lords. મારી પાસે હાલમાં પૈસા નથી તારાથી થાય તે કરી લે તેમ કહેતા સંજયભાઈ અને ફેનિસ વચ્ચે બોલ I am your lord. મારી પાસે પૈસા હાલમાં નથી તારાથી થાય તે કરી લે તેમ કહેતા સંજયભાઈ અને ફેનિસ વચ્ચે બોલાચાલી તેમજ ગાળાગાળી કરી એકબીજા સાથે ઝપાઝપી કરી ઝઘડો કરવા લાગેલ. તે દરમિયાન આ ફેનિસ સાથે આવે એક માણસ ત્યાંથી ભાગી ગયેલ અને બીજો માણસ આ ફેનિસ સાથે રોકાઈ તે પણ ઈ સંજયભાઈ સાથે ગાળો બોલી ઝઘડો કરતો હોય હું વચ્ચે પડેલ. આ બધાને સમજાવવાની વાત કરતો હતો તે વખતે આ ફેનિસ તેની ગાડીમાંથી એક બંદૂક કાઢેલ અને સંજયભાઈને તેમની ગાડીમાંથી એક લાકડી કાઢેલ લઈ આવેલ અને તે વખતે આ ફેનિસ તેની બંદૂકથી મારી ઉપર ફાયરિંગ કરતા મને જમણા પગે ઢીંચણની નીચેના ભાગે ગોળી વાગતા હું ત્યાં બેસી ગયેલ અને આ સંજયભાઈને તેમની હાથમાંથી લાકડીથી આ ફેનિસ પટેલ અને તેના સાથી આવેલ અને લાકડીથી જેમ ફાવે તેમ મારવા લાગેલ. That is the crux of the matter that Fenis Patel fired with illegal weapon to the Ishwarbhai Mohanji, who is the victim, who is the complainant, my lords. And then after this honorable court grants the bail to the Fenis regular bail, and my lords may kindly see the order and condition number 5 and 7 on page number 11. Condition number 5, surrender passport if any before the consent court within the week. If do not process any passport, then he shall file affidavit to the effect before the consent court, my lords. Till date, he never appeared before the court, yet he is not giving passport to the concerned position or to the concerned court. 17th warrant has been issued to this Fenis Patel. he is not giving any support to the any cooperation to the investigation officer, my lords. Till date. From the very beginning, he is not present before the court, my lords. Then after, my lords, not leave to the 7 number condition is not to leave the country India without prior permission of the court. My lords, once he visited to Dubai, posted photo on the Instagram. I'm not having any supportive evidence to give before the honorable court, but my lords, he once visited Dubai, also having that stamp of Dubai immigration to his passport, my lords. My lords, he breached all the conditions put by this honorable court, my lords. Then, my lords may kindly see the page number 12 and 14, my lords. This is the application given by the Ishwar Bhai and Sanjay Bhai to the Bauru police station, where he is residing. Twice he tried to threat, and twice he tried. My lords, may kindly see 14. I am reading this application, my lords. 14, my lords, page number 14. Ishwarbhai Mohanbhai Rabai, I am the complainant on Fanish Anilbhai Patel, is accused of, despite being released on regular bail, Fanish Anilbhai Patel continued to exhibit dangerous and the unlawful behavior on 16 June 2024 and approximately 10:30 p.m. while I was traveling between the village Vamaj and Adraj on Canal Road. I encountered a black tint white Creta car without a number plate, driven recklessly at high speed on continuous honking. To avoid any accident, I allowed the car to pass. However, due to the dangerous driving, I maintained a safe distance. The car then stopped abruptly in front of me, and I slowed down my vehicle. And Fanish Anilbhai Patel emerged from the car holding firearms. Fearing for my life, I accelerated my car to escape. Fanish followed me for a distance. Before diverting his path, when I was reached near my village, his action demonstrated a blatant disrespect for the law and pose a significant threat to my safety and the safety of others. My lords, again, he came with the firearm. He is a 20-year-old boy, my lords. In the public area, first he fired. Adalat, my lords, he fired to this Ishwarbhai Mohanbhai. Bullet go through his right leg. He is gone under to the 2 medical surgeries. And again, my lords, he came with the firearms and gave the threat. He also breached the condition of this honorable court. He also, his conduct shows that he is not having any fear of law and order, my lords. My lords, he is not yet, not plea has been recorded, not even the, my lords, charge has been framed, my lords. Since 4 months, my lords. Please, hold it.
Submit the reply on affidavit. The above findings are there.
રહીને બેન જાગૃત છે.
Oh, see.
Have you surrendered your passport? Whether he is having passport? What was the reason?
Actually, I don't know about it.
You should remain present with all information. What was the reason not submitting or not surrendering passport? I will not hear you. You should have to. બાકી રાખો.
Sufficient time was given to him. Since this,
5:30 સુધીમાં મેડમ માહિતી લઈને આવો.
please.
બોલ. 48-23 21-12
કોમ્પ્રોમાઇઝ માટે પેલા જે human rights માં જે next to that નામદાર કોર્ટે એવું કીધું કે બંનેને હાથે રાખે
શું છે શું ઇસ્યુ?
હાલના જે અરજદાર છે એમનો એમને જે કરાવી સમાવાળાએ વાર્ષિક કરાવી એમાં સાહેબ આપનો હક દુભાયો તો પેઢીનામું કરીને એમને એમની વાર્ષિક કરાવી છે એમનો વારસો નથી એ રીતે સાહેબ નામદાર કોર્ટે અગાઉ એમ કે અરજદારના સામાવાળા બંને ભાઈ બહેન જ છે.
એટલે આ જે જશીબેન છે એને વિડ્રો કરવી છે રિવિઝન?
ના વિડ્રો નથી કર્યું સાહેબ એમનું વારસાઈ કરી આપે સાહેબ મારું નામ લાવી આપે તો અમને કઈ વાંધો નથી.
પણ એ તો ત્યાં ચાલતી હશે ને રેવન્યુમાં, તો ત્યાં કરીને અહીં વિડ્રો કરવી પડશે ને.
આજની તારીખમાં કહીએ છીએ 1 ને 7 બહેનો છે 7 ના નામે લઈ લીધું.
તો ત્યાંનું રેવન્યુ રેકોર્ડ રજૂ કરજો ને. ત્યાં જે પ્રોસિડિંગ્સ ચાલ્યા હશે
તે અમારી વારસાઈ થવા નથી દીધી.
ના 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 એવું છે જ નહીં સાહેબ એમને જ્યાં બી કરી ને ત્યાં અમે રિપ્લાય એવું જ આપી દો તો અમે એમની વારસાઈ કરાવવા માટે તૈયાર છીએ. ધોરણની સાથે
એમને કોપી આપી દો ને. પણ
એમની જોડે છે સાહેબ ઓર્ડર બી મળી ગયો છે એમની પ્રાંતનો ઓર્ડર છે પણ એટ ધેટ ટાઈમ એમને સાહેબ પેઢીના મુદ્દે રજૂ ના કર્યું ને એટલે એમની ડિલેના કારણે કાઢી.
પછીનું તમારું જે સબમિશન છે ને આપવા તૈયાર છો એની કોપીઝ આપી દો તો આ પૂરી થઈ જાય.
આપવું પડે સાહેબ પછી અમને કોઓપરેટ ના
તમારી
થાય.
તમારી પાસે લેખિતમાં ખરું એ જે બોલે છે?
દાદા એ જે ઓર્ડર છે ને એ ઓર્ડર ની અંદર જ પ્રાંત અધિકારી સાહેબે લખેલું છે અને આ ઇન્કવાયરી જે છે ને એની અંદર જે બી તપાસ થઈ ને એ તપાસ નામદાર કોર્ટ સમક્ષ રજૂ થઈ ને એમાં પણ એવું લખેલું છે આ સામાવાળા આ જમીન વેચી નથી અને એમની બહેનોનું નામ દાખલ થવા માટે તૈયાર છે. હું સાહેબ ઓર્ડરમાં પણ લખેલું છે.
પણ તમે બોલો છો
પણ એ તમારે લેખિતમાં આપવું પડશે ને.
પેઢીનામું બનાવવા જઈએ તમે અમારો વાંધો લો તો પછી શું
પેઢીનામું તો
કરવાનું?
અમે જાતે જ બનાવવા તમે ખાલી કોઓપરેટ થાવ કારણ કે ત્યાં શું થાય તમામ વારસોનું પેઢીનામું આપવું પડે. 7 બહેનો તો સાથે નો સહી ફોટો બી આપવા પડે. અમે એ માગીએ છીએ એ આપી દે તો બીજા રિયસ કરી દઈએ તમારી સામે. ત્યાં સુધી આવું પૂરા
અમે તો સાહેબ અમારા પૂરતું પછી બીજી બહેનો અમારી જોડે ના આવે
કોઈનો બાકી નથી રાખવા
તો
સાહેબ.
પછી
7 બહેનો છે એક ના આપીએ 9 6 ને શું લેવાના આપીએ બધાને આપવું છે.
નોટિસ ઇસ્યુ થઈ છે ત્યાંથી?
ત્યાં તો ઓર્ડર એમને ડિલેના કારણે
ડિલેના કારણે સાહેબ.
94 માં સાહેબ આ વારસાઈ જે થઈ હતી
એટલે સાહેબ સંમતિ સિવાય થાય એવું નથી. એટલે જો કોઓપરેટ થતા હોય તો જ આવે એવું છે.
ના કોઓપરેટ હું નામદાર કોર્ટમાં તૈયાર જ છે સાહેબ. અમારા પોતે
તો ત્યાં લેખિતમાં આપીને પછી આવો ને અહીંયા.
ત્યાં તો પણ એમને સાહેબ કલેક્ટરમાં અપીલ કરવી પડે ને અપીલમાં અમે કહી દઈએ કે આ અપીલ મંજૂર કરવામાં અમને વાંધો નથી અમારું નામ દાખલ થાય.
બસ તો સાહેબ મહિનાની
ત્યાં
તારીખ
હા
અમે યાર અરજી કરી
21-12 રાખું છું અત્યારે. એ પૂરો ન થાય ત્યાં સુધી આ બેનને ન લાવતા. દાદરા ચડવાની તકલીફ પડતી હશે,
સવારે
પૂરું કરીને આવો. કઈ વાંધો નહીં, કઈ વાંધો નહીં. પણ આવતી હવે એટલે પૂરું કરીને પછી લાવજો એમ. કલેક્ટરમાં જે કઈ અપીલ કરો એમાં પ્રોસિડિંગ્સ પૂરા થાય પછી એમને ધક્કો ખવડાવજો.
with affidavit. With affidavit.
આ તમે જે જીમેલ નું કયો છો એની તો કોપી મૂકો.
એવું નથી સાહેબ.
તમે આમાં કયું છે જીમેલ ઉપરથી આવ્યું છે તો એની કોપી તો હશે.
અમે જે કોલ કરીએ એમાં આઈડી એ આવે છે સાહેબ. ટ્રુ કોલર માં સાહેબ એવું છે સાહેબ.
એમાં એમણે સર્ચ કર્યું ને તો જોડે આ નંબરની જોડે
તમે એ આવે
મેલ આઈડી પણ આવે એટલે એમણે લખી.
એટલે મેં એવું લખ્યું છે.
અત્યારે હું સાંભળવા માટે રાખું છું દાખલ કરવી કે કેમ, કારણ કે નોટિસ 406 420 તમે આમાં લખ્યું છે એનાથી વધારાની
સાહેબ,
ટેક્સ
એને
પણ આવી
જે
શકે.
ફોન ઉપર થી આવ્યો એને મને કીધું કે ભાઈ આ કીધું છે.
ફોન ઉપર પોલીસમેન જ હતા કે એનું કંઈક વેરિફિકેશન તો કરવું પડશે ને.
હમ.
એમને આવી જશે ફોન અને એમને એન્ટિસિપેટરી દાખલ થઈ શકે. લેમેનને ન ખબર
પણ
પડે
સાહેબ
પણ
મારી તો
વકીલ-
ધરપકડ કરવાની ચાન્સી સાહેબ આપ સાંભળવા માટે રાખે અને મને પકડી શું કરવાનું સાહેબ? આ પોઝિશન છે સાહેબ.
પણ તમે
એટલે સાહેબ એન્ટિસિપેટરી
પણ એ તો
દાખલ કરવાનું કારણ એ છે કે મારી ધરપકડ ના થઈ શકે એટલા માટે હું કરું છું સાહેબ.
406 420 સિવાયની વધારાની નીકળે અથવા તો ઓછી નીકળે તો
એ
કોર્ટ
નીકળશે સાહેબ, એ ઉમેરો કરશે સાહેબ. જે એફઆઈઆર
પછી
પટશે સાહેબ,
પછી
એફઆઈઆર ઉમેરો કરશે સાહેબ. બીજું એફઆઈઆર હજુ બાકી
એફઆઈઆર
નથી
ની
સાહેબ.
જરૂર નથી મિસ્ટર એડવોકેટ.
નથી.
જે અરજી કયો છો એ અરજીનું કંઈક જોશે.
હમ.
તમને અરજી આવી હશે તો નોટિસ આવશે. એમને કોઈ નોટિસ વિના પોલીસ અર્નેશ કુમારના જજમેન્ટ પછી કરશે અરેસ્ટ?
સાહેબ કરી લે તો શું કરવાનું?
નોટિસ
નથી.
સિવાય તો કેવી રીતે કરશે?
સાહેબ પોલીસને તો બધા પાવ છે, પાવી લઈ રહેશે. રાખો
બાકી રાખો.
સાંભળવાનું લઈ રાખો.
હા હા, અત્યારે નંબર બંબર કાંઈ નહીં, એના ફાઇલિંગ નંબર એ ન પડે. એમને નોટિસ આવશે કે અરજીની કોપી આપે, પોલીસ સ્ટેશન જઈને એ મેળવી શકશે ને. 16 રાખો, 16/11 તમે પોલીસ સ્ટેશન જઈને અરજી નકલી લઈ જ શકો છો ને આવી હશે.
ઓકે.
બસો 53.
હાજી.
રાઈટ ક્લોઝ કર્યું તો